everybody. Well, part 32. We're coming up to the end of this saga. Part 32 of the $80 ticket saga. As I said in part 31, this is going to be my response from the defendant to the Memorandum of Counsel for the police on the application by the defendant for costs. So remember I said they'd given me a 35-page response. Well, there's my 65-page answer. So I'm going to read it out to you. It's between the police, which is the prosecution, versus the defendant, Mark Donald Eric Keane, the corporation Sol. CRI 2017 004 005501. And this was dated on the 9th of April 2018. May it please the court. In response to the Memorandum of Counsel for the police on application by defendant for costs, or memo, dated 23rd of March 2018, authored by Miss Kate L. Blackmore, the defendant submits the following for the court to consider. All references referred to below can be found at the end of this submission. Below are the facts of this matter to date, 9th of April, as recorded or recalled by the defendant. Little do they know what I have recorded. Background, previous appearances and initial submissions. 1. First appearance, 13th of July 2017. 1.1. Counsel for Police Miss V. Hicks, the first prosecutor, the prosecution, appeared for a preliminary hearing at Auckland District Court ADC on the 13th of July in respect of an alleged infringement offence of exceeding an alleged temporary 80 km/h speed restriction pursuant to sections 40 and 133 of the Land Transport Act 1998, or the LTA, regulations 3 and 4 of the Land Transport, Offences and Penalties Regulations 1999, or Offence Regulations, and Rules 5.1 of the Land Transport Road User Rules 2004, or Road User Rules. 1.2. The infringement offence is a finable only matter with a maximum fine of $1,000 that Mark Donald Eric Keane, or the defendant, was liable upon conviction under the criminal standard of beyond reasonable doubt, or BRD, refer to page 16 of the November 7th transcript, to pay. 1.3. Until such time the defendant shall maintain a presumption of innocence in accordance with the New Zealand Bill of Rights Act 1990, Section 25, or BORA 1990. The infringement fee for the alleged offence was $80 and the burden of proof, or onus probandi, is for the prosecution to satisfy every element of the alleged offence, or element. 1.4. Those elements were that the defendant had on the 22nd of April 2017 at 12:15 p.m. A. drove on the Northwestern Motorway, State Highway 16, and B. drove at a speed exceeding a temporary speed limit of 80 km/h, and C. that a temporary 80 km/h speed restriction was in effect, and D. the allegation being that of an offence. 1.5. Prior to being heard, the defendant was surrounded by 4 ADC security officers and police.
I've just had direction from the judge to take all your recording equipment off you and give back to you when you leave the court.
Why is that?
Because of, I believe it's because of some stuff that's been put up on the internet. I have an email from the judge directing me.
Can I see that email?
No, you can't see the email.
Well, then I can't just take your word for it. Sorry,
well, yeah, that's what I say is, well, then you can't leave the court with it. With your equipment, you either give me your equipment or you have equipment. One of the
So am I being denied the right to be heard?
No, you're not being denied the right to be heard. All I'm saying is I take your equipment and then you can seek permission from the judge. If he says you can, I'll give it back to you.
There's no need for you guys to stand around me. I don't need this intimidation.
This is my court, I'm running my court.
That's cool.
You don't need to tell me what I have to do.
You're a public servant, aren't you? Great, I'm not interested in talking to you.
Okay. Registry seeks your honest direction to hold all of Mark Keane's recording devices while he is attending court today. You just have a look in your bag to make sure there's nothing else, please. Do you have a phone on you?
It's in my bag. What's that?
Because that's recording the process. Now, I myself have appeared in your videos myself.
I know we have, Grant. What of it?
while the defendant sat quietly awaiting to be called inside courtroom 2. The defendant was then given an ultimatum by Grant, an ADC security officer. Grant was known previously to the defendant from another matter in 2015. The defendant was then forced under protest and duress to surrender the defendant's possessions, cameras and phones, or be removed from Auckland District Court and not be heard, breaching the defendant's right under BORA 1990 Section 21 to be free from unlawful search and seizures, unlawful SS. This incident had occurred due to a Rita Lopez, Registrar of Auckland District Court, seeking direction 12 minutes before this matter was to be heard at 2:03 p.m. via email from His Honour Judge T.M. Black, or Judge Black, to have the defendant's recording equipment seized. The direction sought was then in response given by Judge Black 2 minutes later. The defendant submits to the court that this disrupted, confused and upset the defendant, as the defendant had been informed the reason for being placed on a judge's list for that time and place was to discuss the defendant's pre-affirmed right to seek, receive and impart information and opinions of any kind in any form, refer to BORA 1990 Section 14, namely, to audio and video record the proceedings, refer to ADC from Georgina 3 July and re-recording. Given that this discussion did not happen, and Rita Lopez's actions to seek Judge Black's direction, refer to email from Rita to Judge Black, Rita's email, had clearly affected the impartiality of the judge, given Judge Black's actions and comments soon after, such as Judge Black stating that the defendant had some agenda, inter alia, during the brief preliminary hearing for this matter, refer to page 7 of the July 13th transcript, 2017. The defendant further submits to the court that following due process of law should not be considered an agenda. The defendant sought to be fully and fairly informed as to the nature and cause of the action alleged. The defendant requested points of clarification as to make a fairly and fully informed, willing and voluntary plea. Judge Black proceeding then to enter a deemed not guilty plea on behalf of the defendant.
But am I entitled to make a fully informed plea?
Deemed not guilty plea.
Are you entering so my intention today is to enter a fully signed plea of guilty. I have one right here in my hand.
Alright, well, I'll interrupt you.
I have some questions to ask before I can do that.
30 seconds and I'm entering a deemed not guilty plea. I'm not having this conversation. I'm not wasting my time with someone who wants to have some.
I wish you to enter a fully informed plea, Your Honour.
Deemed not guilty.
Are you entering a plea on behalf of me, Your Honour?
Yeah, because you're refusing to enter a plea.
Are you practising law from the bench, Your Honour?
I think you can't.
Are you practising law from the bench? Are you
Don't talk to me like that, Mr. King. I hold you in contempt and have you detained. Stop wasting my time.
This was done against the defendant's wishes, expressed intent and direction. Judge Black then threatened the defendant with detention and contempt of court, refer to page 8 of the July 13th transcript, for seeking points of clarification. A deemed not guilty is understood by the defendant according to the Criminal Procedure Act 2011, CPA 2011, Section 39(1), that there is a requirement for the defendant to plead if the court is satisfied that the defendant has had initial disclosure in accordance with the Criminal Disclosure Act 2008, CDA 2008, Section 12(1), which had not in this case occurred. A complaint was filed by the defendant with the Judicial Conduct Commissioner against Judge Black as a result of this. At that time, the defendant had received the initial infringement notice, the blue copy, PR 1058327, and a cover note dated 1st of the 5th, 2017, PR 1058327, which did not have any legal provisions noted on it. The defendant then sent a response dated 8th May 2017 to New Zealand Police Infringement Bureau, or NZPIB. Following this, the defendant received on the 5th of June a cover note dated 30th of May 2017, missing any summary of the defendant's rights to apply for further information under Section 12(2) of the CDA 2008. This cover note was accompanied by one photograph, 635-643-561, one charging document, notice in respect of an infringement offence, CRN 1700 417 6889, without any legal provisions referenced, and 1 times defendant's emails and 2-page response to New Zealand Police Infringement Bureau dated the 8th of May. These were supplied to the court for inspection on the 7th of November 2017. The defendant submits that this failed to fulfil the requirements for initial disclosure under CDA 2008 Section 12.1. A further request for documents required under CDA 2008 Section 12.1 was sent to the Police Prosecution Service, or PPS, prior to this preliminary hearing. This request was sent on the 15th of June 2017, which also remained without response from PPS. During the July 13th preliminary hearing, Ms V. Hicks did not at any time identify herself or speak to the defendant, and it was only after receiving and reading the transcript from the 13th of July on the 4th of August that Ms V. Hicks was identified. This was the first instance that the prosecutor's identity was made known to the defendant. As the defendant was holding up a pre-written guilty plea with the expressed intent to sign upon being informed of the nature and cause of action, and according to CPA 2011 Section 41, a defendant is deemed to have pled not guilty only if the defendant had refused or failed to do so. The defendant's intent wasn't expressed, and the defendant neither refused nor failed to plead. The defendant wished to be informed fairly and fully prior to doing so, in accordance with BORA 1990 Section 24A. As the defendant's clarifications remained unanswered at that time, and given the threatening demeanour of Judge Black, the defendant elected to file a motion via email to have the deemed not guilty plea entered by Judge Black struck on the 3rd of October 2017, which was filed with ADC Registry. The defendant at that time had still not received a summary of facts, traffic or criminal histories, nor had the defendant been informed of the defendant's right to seek for further information under Section 12.2 of the Criminal Disclosure Act 2008. Refer to CDA 2008 Section 12.1b. This in fact contradicts the statement within the cover note from New Zealand Police Infringement Bureau dated 30th of May that this fulfills the requirements of initial disclosure under the Criminal Disclosure Act Section 12.1. Further, correspondence dated the 23rd of July and 3rd of October was sent to the PPS requesting documents required under the Criminal Disclosure Act 2008 Section 12.1. They were A. Summary of facts, which have the provisions of maximum fine noted, refer to Criminal Disclosure Act Section 12.1a, Criminal Disclosure Act Section 12.1c, and Criminal Procedure Act 2011 Section 17.5a. Provisions first received by hand on the 7th of November 2017. B. Proficiency certificate relevant to the operator, the witness, received on the 11th of October 2017. License status never supplied. Instrumental authorization received on the 11th of October. Deployment register for the registration plate EUR 591 on the 22nd of April 2017. Refer to Criminal Disclosure Act Section 12.2f, received on the 11th of November. Daily logbook, if applicable, refer to Criminal Disclosure Act Section 12.2e. Notes made at the time of this matter, refer to Criminal Disclosure Act Section 12.2e. H. Demerit history, refer to Criminal Disclosure Act Section 12.1d, first received by hand on the 7th of November 2017. Previous traffic and criminal history, refer to Criminal Disclosure Act 2008 Section 12.1d and Criminal Disclosure Act 2008 Section 13.3d, first received by hand 7th of November. Witness list, as 13th July 2017 transcript mentioned one witness, refer to Criminal Disclosure Act Section 12.2a, received 13th of November via email, created by Sergeant Mike McMurtry, post 7th November. Any evidence supporting a temporary speed restriction of 80 km per hour in effect, facts not in evidence. Note, photograph 635643561, refer to Criminal Disclosure Act Section 12.2g, was not requested as this item had been supplied to the defendant on the 30th of May by New Zealand Police Infringement Bureau. In total, 4 separate requests were made to the New Zealand Police Infringement Bureau and Police Prosecution Services for the above items, and in fact the first response from Police Prosecution Services was on the 6th of October 2017 from a secondary email auckland.pps.office@police.govt.nz. The initial email address stated by New Zealand Police Infringement Bureau on the 30th of May cover note was pps.auckland@police.govt.nz for correspondence, which remained without response to the defendant, other than to send an automatic reply or confirmation each time acknowledging receipt of the defendant's requests on the 15th of June, 23rd of July and 3rd of October. Refer to page 15 of the November 7th transcript. These requests and confirmations were submitted to the court for inspection and filings on the 9th of February 2018 in response to Her Honour Judge Mather's request from the 7th of November 2017. On the 11th of October 2017, the defendant received via post from a brief of evidence authored by unauthenticated, without signature, without date, stating he was the operator of the 22nd of April 2017 of the Redflex radar cam or S-cam or scam. However, the brief of evidence did not refer to either the defendant or the registration plate FAN 394 anywhere within its contents. Note, at the bottom of this brief of evidence was one certificate of proficiency for one certificate of accuracy for the scam, one deployment register for the 22nd of April 2017, no mention of any photo being supplied. Note that this was in contradiction to the witness's testimony later during the 9th of February 2018 hearing. A certificate of authorisation was also received but not noted on the brief of evidence. The defendant submits that the prosecution had continued to fail to supply the defendant with initial disclosure in accordance with Criminal Disclosure Act 2008 Section 12(1), which had been requested now for on 4 separate occasions and ignored. Second appearance, 7th of November 2017. Counsel for the Police, Sergeant Mike McMurtry, the second prosecutor, attended on the 7th of November 2017 at Auckland District Court, Courtroom 11, with Her Honour Judge Mathers presiding, for the second hearing in relation to this matter. After first being called at 10:42, the defendant again sought to be fully and fairly informed of the nature and cause of action in respect to the alleged offence. Her Honour Judge Mathers, while putting the charge to the defendant, referred to the page 7 of the November 7th transcript, noticed there were no references to any section or regulation provisions within the charging document. The defendant submits that the charging document therefore failed Criminal Procedure Act 2011 Section 16(2)(d) and Section 17(5)(a), as the provisions were not informed to the defendant on the charging document and no offence was created. Refer to page 11 of the November 7th transcript. The prosecution assumed, be it incorrectly, that the defendant had been supplied a summary of facts. However, as the multiple requests confirmed to have been received by Police Prosecution Services through email acknowledgements show the summary of facts which have the provisions noted inter alia being sought by the defendant as they had not been provided by the prosecution to the defendant. The defendant submits that as the provisions first appear on the reminder notice, refer to Summary Proceedings Act 1957 Section 12(1)(b), which had never been created in this matter, then secondly the provisions are then transferred to the charging document in theory, and then thirdly the provisions appear within the summary of facts in accordance with the Criminal Disclosure Act Section 12(1)(a) and the Criminal Procedure Act Section 17(5)(a), as above in 119(a). At that time, no summary of facts had been provided to the defendant, and thus the defendant had still not been fully or fairly informed to sufficiently make a willing, knowing and voluntary plea. Disturbingly, on page 13 of the November 7th transcript, counsel states, infringements have been issued for years and years, and this doesn't appear to have been raised before inter alios, and continued by stating, that's something that needs to be looked at in the system. Her Honour Judge Mathers then appointed an amicus curiae, refer to page 23 of the November 7th transcript, to assist the court and the matter that was stood down at 11:09 a.m. Refer to page 26 of the November 7th transcript. While the defendant, upon direction from H.H. Judge Mathers, or Her Honour Judge Mathers, spoke with a duty lawyer, refer to page 25 of the November 7th transcript, the defendant was supplied by hand from the prosecution a summary of facts, traffic, criminal and demerit history just prior to meeting with the duty lawyer as directed. Once spoken with the duty lawyer, unknown identity, he stated, "Good on the judge for pointing that out."
Good on the judge for pointing that out. I think that's a fairly fatal error.
Yeah.
That notice is part of
I made
the
her read it
procedure.
out.
It's part of the procedure and it's defective in its form.
Referring to the missing provisions, that the charging document was defective as part of the procedure and fraud, as the prosecution had failed to follow due process. He further stated, "It's a fairly fatal error. This is in contradiction to the prosecution's memo." 32, where they say they had sufficient grounds in a strong case. Once reconvened at 12 p.m, Her Honour Judge Mathers directed the prosecution to look at the Section 21 of the Summary Proceedings Act 1957, SPA 1957, Rule 2.1 of the Criminal Procedure Rules 2012, and Section 204 of the Summary Proceeding Act 1957. The matter was then stood down until 2:15. At approximately 1:30, the defendant was introduced to Roger Chambers, amicus, by the Court Security Officer Grant. The defendant spoke with the amicus for approximately 45 minutes prior to reconvening at 2:15. Upon reconvening at 2:21, the court briefly dealt with another matter and then court resumed at 2:35 p.m. Even though the prosecution had conceded prior to that the defendant had not received initial disclosure, the prosecution then stated the police file does indicate the disclosure was made to the defendant of the prosecution file, and that's from a report compiled by Inspector Kelly Ryan at the New Zealand Police Infringement Bureau, known as Report. Refer to page 35 of November 7th transcript. This report was not supplied to either the court or the defendant by the prosecution for inspection. Her Honour Judge Mathers then issued an order under Section 30 of the Criminal Disclosure Act 2008 for the prosecution to supply full disclosure by the 14th of November by email and post. The matter was adjourned again until the 9th of February 2018, 9:30 a.m. On the 13th of November 2017, the defendant received a disclosure package via email and post from the second prosecutor, which failed to include the report from Inspector Kelly Ryan that the prosecution had referred to during the 7th November 2017 hearing. Refer to page 35 of the November 7th transcript. On 8th of January 2018, the defendant received via email the transcript for the 7th of November 2017 from Auckland District Registry. Upon reviewing the 7th November 2017 transcript, the defendant requested on the 31st of January 2018 a copy of the report as above in Section 2.8, which was supplied by the second prosecutor on the 31st of January, 2.5 months after the Criminal Disclosure Act 2008 Section 30 order from the 7th of November 2017. Motions for dismissal and costs, and an application to video and audio record the proceedings set for the 9th of February 2018 were also filed by the defendant via Auckland District Court and PPS on the 31st of January. On the 5th of February, the defendant received an email from the amicus refer to 5 February 2018 from amicus with attached 2-page document, or the amicus 5-bed email. Enclosed within the attachment, the attached PDF document, the amicus attempted to compel the defendant to state whether the defendant was the alleged driver or not, twice. Refer to paragraphs 8 on page 1 and 2 on page 2. The defendant submits to the court that this has breached the defendant's rights under the Bora 1990 Section 25D to not be compelled to be a witness or confess guilt. The amicus expressed This was the sole issue for the court. Refer to page 1, paragraph 9 of the amicus 5 February email. The amicus considered the defendant's filing to be a plethora of paperwork. Refer to page 1, paragraph 10 of the amicus 5 February email as above 213. The defendant responded on the 6th of February, just one day later, 2018, to assist the amicus with his difficulty expressed in his correspondence. Refer to page 1, paragraph 2 of the amicus 5th February email. 3. Third appearance, 9th of February 2018. Counsel for the police, Miss Kate Blackmore, the third prosecutor, attended on the 9th of February 2018 at Auckland District Court with HH Judge Nicola Mathers presiding. The defendant application to video record was refused. HH Judge Mathers ensured to the best of the court's endeavours, along with the assistance of the court registrar, that the court audio recording system was in operation and functioning properly. This was confirmed at the time.
The registrar to make sure you just check that everything was being
During this trial, which lasted in total approximately 5 hours, the prosecution called as witness operator of the unmarked Hyundai van registration plate EUR 591, which the Redflex radar cam or SCAM was operating within, to give testimony. Upon testifying, the witness produced a certificate of proficiency for the witness as Exhibit 1, yet failed to correctly answer several questions upon cross-examination that were derived from DUT 244 Speed Camera Operators Module 2001, filed into evidence for the defendant, and an updated 2015 Operator's Manual would be filed on the 28th of February 2018 after obtaining it under the Official Information Act request to the New Zealand Police Infringement Bureau. Note: Counsel stated within the memo in section 10, including there was no cross-examination. This contradicts another statement within the same paragraph of the memo where counsel states the defendant had the opportunity to cross-examine the witness in the judge-alone trial on the factual and legal matters he denied and various other it has submitted irrelevant issues. Therefore, the defendant submits to the court that the issues raised by the defendant were indeed relevant due to 1. As the first-hand witness being able to identify the defendant as being the alleged driver, and 2. Requiring evidence of an 80 km/h speed restriction being in effect. No admissible evidence or positive identification was given by the witness in relation to these relevant issues. B. The witness produced one certificate of accuracy for the SCAM as Exhibit 2, being the SCAM operated for detecting offences on the 22nd of April 2017. The witness testified the SCAM was calibrated using a tuning fork serial number 012896, which he had used on the 22nd of April 2017 for calibration. The witness failed to show any certificate towards the accuracy of this tuning fork. C. The witness produced one-time instrumental authorization for the SCAM as Exhibit 3. The witness produced one-time speed camera deployment register as Exhibit 4. The witness produced one-time photograph 635643561 photo as Exhibit 5. The witness showed registration plate FAN 394 facing westward on the northwestern motorway, State Highway 16. The photo lacks the clarity to ascertain the face or identity of the driver. The defendant submits to the court that Exhibit 5 has failed the criminal standard of beyond reasonable doubt, as the driver's identity cannot be established. F. The witness produced a certificate of particulars by New Zealand Transport Agency, or NZTA, for registration plate FAN 394, page 1, dated the 26th of May 2017, as Exhibit 6. This document shows two registered owners, Mark Donald Eric Keane and the defendant furthermore submits to the court that Exhibit 6 has also failed the criminal standard of beyond reasonable doubt, as there are at least two possible drivers. Note: Counsel is repetitively referring to the vehicle registration plate AAW69 within this memo, 9B, D, 9BH and 9BI. This is another error by the prosecution, as AAWU69 was the site location noted on the deployment register, prosecution exhibit 4, as above 3.4D. This was not the registered owner's registration plate noted in exhibit 5. During cross-examination by the defendant, A, the witness failed to verify the defendant was present or the alleged driver of the registration plate FAN394, a 2002 blue Mitsubishi Dion private motor car. The witness gave testimony and evidence that the defendant was one of the two registered owners of the private motor car associated with registration plate FAN394. Note, registration plate FAN394 is not mentioned anywhere within the memo submitted by the prosecution. The defendant submits to the court that without a first-hand witness for the prosecution to verify the identity of the alleged driver, that the prosecution had relied solely on presumptions prescribed within section 133(2)A of the Land Transport Act, and the photograph without the alleged driver's identity visible. Therefore, the prosecution did not have sufficient evidence to pursue prosecution against the defendant in this alleged criminal offence to the standard of beyond reasonable doubt. Given the lack of identification of the alleged driver that can be obtained through the prosecution's evidence submitted, and contradicts paragraph 35 of the prosecution's memo, where the counsel states the prosecution submit that the evidence sufficiency of the prosecution case was strong. Bullshit! The prosecution's allegations appear to be based on presumption under section 133 subsection 2A of the Land Transport Act, where it is prescribed that the registered owners must be presumed the alleged driver. However, the registered owners can, if wish, as a defence, make a statutory declaration. Nowhere within section 133 subsection 4C of the Land Transport Act it is described that the registered owners must make such a declaration, only that it is a defence if the registered owners wish to do so. Refer to Bill of Rights 1990 section 25D. Note, according to Black's Law Dictionary, 6th edition, Black's Law, page 707, must is defined as must. This word, like the word shall, is primarily of mandatory effect, and in that sense is used in antithesis of may. But this meaning of the word is not the only one, as it is often used in merely a directory sense, and consequently is a synonym for the words may, not only with the permissive sense of that word, but also in the mandatory sense which it sometimes has. So in other words, must means may, and therefore also may not. Therefore, as LTA is using the word must in a directory sense, it is a synonym for may and consequently may not. B. The witness failed to identify the defendant with the prosecution's evidence produced. Refer to Exhibit 5, the photograph. The witness claimed to have supplied the defendant with a photo inter alia, among other things. However, the defendant in fact received the photo from the New Zealand Police Infringement Bureau on the 30th of May 2017 and was not supplied any photo from the witness. Therefore, you lied. The witness failed to produce evidence of a temporary 80 km/h speed restriction being in effect for the 22nd of April 2017 and testified his boss had told him it was noted in the New Zealand Gazette, which being hearsay is inadmissible as no copy of the New Zealand Gazette was produced by the witness for evidence. Just because your boss told you so doesn't mean that that's satisfactory in a court of law. The matter was then stood down at approximately 4:30 p.m. with submissions from the prosecution to be provided to the amicus, ADC Registrar, and the defendant by the 2nd of March 2018. The defendant was to respond by the 23rd of March 2018 in turn, and by the 13th of April 2018, the defendant was asked to provide any submissions on why the defendant believed the case should be dismissed by the court. The matter had been adjourned until the 26th of April 2018 at 10 a.m. 4. Her Honour Judge Mathers Minute, 16th of February 2018. On the 16th of February 2018, the defendant received via email a minute from Her Honour Judge Nicola Mathers stating 1. That it had come to Her Honour's Judge Mathers' attention that despite Her Honour's endeavours to ensure that the recording system was operating, it had transpired unfortunately that it was not. 2. Her Honour noted that the defendant's anxiousness to have a full recording and ordered that the defendant receive a copy as soon as possible. 3. Her Honour had wished to see the parties to decide how this matter was to proceed, if at all. And 4. Her Honour invited both parties to make submissions in person to the court on the 28th of February 2018 at 10 a.m. Her Honour then adjourned the matter to that date. The defendant replied on the 18th of February 2018, accepting the invitation. 4th appearance. Counsel for the police, Miss Kate Blackmore, the third prosecutor, attended again on the 28th of February 2018 at Auckland District Court, Courtroom 3, with Her Honour Judge Nicola Mathers presiding. The defendant application to record, dated the 28th of February, was refused again by Judge Mathers. Judge Nicola Mathers then verified with the senior registrar and court taker that the court audio recording system was in operation and functioning properly. Her Honour Judge Nicola Mathers via email had also confirmed that the transcription service were also monitoring the proceedings. Can't lose another trial of all that's happening, yeah? Judge Mathers stated that the defendant could be supplied a transcript for the hearing that the defendant was presently attending, although this is not normally done. Why not? As 9th of April 2018, the transcript from the 28th of February has not been provided upon multiple requests. No indication as to any time frame has been provided as to when the defendant shall receive the transcript by the Auckland District Court. Although the prosecution alleges in its memo, section 30, that it had sought to have the charges withdrawn on the 16th of February, which is wrong again, the defendant believes this to be another error by counsel and that the prosecution is in fact referring to the hearing held on the 28th of February. The defendant submits to the court that under Criminal Procedure Act 2011 section 146(1), the prosecution may withdraw a charge before trial. However, in this matter, a judge-alone trial had already occurred, and thus why a dismissal was made. The charge was dismissed by consent at the suggestion made by Her Honour Judge Mathers forthwith due to systematic failures inter alia, or among other things, the latest of which being that the Ministry of Justice had lost the entire permanent court record of the February 9th trial, as above section 4.1, and referred to section 184 of the Criminal Procedure Act 2011. Miscarriage of justice. The defendant submits to the court that due to the numerous procedural, regulatory, rule and due process failures by both the prosecution and the Ministry of Justice, which the prosecution to date has taken no responsibility for whatsoever, that a clear miscarriage of justice has occurred. Also note that Her Honour Judge Mathers has stated on the 7th of November 2017, what may persuade me that there's been a miscarriage of justice or that the charge should be dismissed is a combination of the two, and to be satisfied about that you have been asking for this information over a period of time, I would like to see the emails. Refer to page 45 of the November 7th transcript and refer to the Criminal Procedure Act 2011 section 371. The initial combination referred to by Her Honour Judge Mathers included the fact that the provisions were missing from the charging document, making it defective, and that proof of service by way of email confirmations of the defendant's continual requests for information in accordance with the Criminal Disclosure Act Section 12.1 were made to the prosecution and had remained unfulfilled, also failing the Bill of Rights Act 1990 Section 24A. Evidence of these requests have been provided by the defendant for the court to be satisfied that a miscarriage of justice had occurred and was submitted to the court on the 9th of February. This evidence remains on file to date. Well, little did I know, because none of those exhibits 1 through 6 from the witness are in the complete case file. None of anything I submitted in the complete case file. So they didn't just, whoops, forget to start the court audio recording system. No, the physical exhibits were also missing. Errors by counsel within the memo submitted on the 23rd of March. With respect to paragraph 3 of the memo, the defendant has produced facts into evidence on the 7th of November and 9th of February, as the prosecution failed multiple times to supply initial or full disclosure. There was no allegation, as facts and evidence were produced by the defendant on both the 7th of November and the 9th of February. With respect to paragraph 5 of the memo, counsel states the defendant elected not to call or give evidence. This is false, as the defendant had in fact submitted DUT 244 2001 operations module and 4 email acknowledgements confirming multiple requests had been received by the Police Prosecution Service into evidence. The defendant also filed 1 brief of evidence authored by Keith Stubley as the defendant's Exhibit A for this matter. That's gone too, funnily enough. With respect to paragraph 6 of the memo, counsel states, and the parties were directed to appear in person, where in fact the parties were invited. With respect to paragraph 7 of the memo, counsel states, on the 16th of February, counsel advised that the prosecution would seek to withdraw and not proceed with the infringement offence to a rehearing. As a judge-alone trial, or JAT, had already happened, the defendant submits to the court that the prosecution under Criminal Procedure Act 2011 Section 146 can only withdraw prior to a trial and not after. The defendant furthermore submits that the prosecution allegedly sought to withdraw on the 28th of February and not the 16th, although this cannot be confirmed as the transcript for the 28th of February has not been supplied to the defendant as yet. With respect to paragraph 9b(a) of the memo, counsel states that the witness was deployed in his mobile camera van to the northwestern motorway in the temporary speed zone of 80 km per hour. However, no evidence was produced by the witness to confirm that an 80 km per hour temporary speed restriction being in effect upon cross-examination by the defendant. With respect to paragraph 9bd of the memo, counsel states, one of the vehicles which was photographed as exceeding the speed limit was the vehicle registration AAWU69 with a recorded speed of 94 km per hour. As the alleged registration plate is not mentioned, the prosecution had clearly made another error. This error is repeated within paragraph 9bh twice and 9bi. Furthermore, with respect to paragraph 9bh of the memo, the prosecution states that the witness did not at any time receive any notice of statutory declaration from the defendant. Although correct, under the Land Transport Act section 133 subsection 4c, the defendant may use this as a defence if the defendant wishes. However, there is no obligation that the registered owner must do so. With respect to the paragraph 10 of the memo, counsel states, the above facts and prosecution case was for the most part denied by the defendant. This is false, as the defendant had only denied receiving the photo from the witness as claimed, and made no statement to either confirm or deny the witness's testimony in relation to the evidence or prosecution's case submitted. If I'd done that, that would have admitted that I had first-hand knowledge and therefore was there. Do you see that? If I'd said, I wasn't driving that fast, it still means I was driving. The prosecution's claim is that I was. The prosecution's burden is to prove that I was. And I ain't going to say anything that's going to make them think that I was the alleged driver. So by them saying that I was denying what the witness had testified, meant that I had first-hand knowledge. I didn't deny it. All I denied was the fact that the said that he sent me a photograph. That's a flat-out fucking lie, because I had that photograph 9 months earlier from the New Zealand Police Infringement Bureau, and the packet that he sent me on the 11th of October, after my 4 requests, didn't have a photo in it. So, more perjury. The defendant only asked questions via cross-examination to satisfy the onus probandi could be met by the prosecution to the criminal standard of beyond reasonable doubt, which the prosecution had failed to do in this matter. The defendant submits to the court that as no evidence or witness testimony of the defendant being the alleged driver of FAN 394 on the 22nd of April 2017 at 12:15 on the Northwestern Motorway State Highway 16 was produced, and that no evidence of a temporary 80 km/h speed restriction was in effect for that location, that the prosecution had not possessed or provided sufficient evidence to proceed in this matter, contradicting paragraph 35 of the memo, and is solely relying on prescribed legislative presumptions and passive acquiescence from the defendant. And that's how they win, because you guys all shut the fuck up and therefore are agreeing to their allegations. You guys need to learn to have a set of balls and a backbone and stand up. If someone's claiming something, you hold them to the burden. It's that fucking simple. Stop being fucking sheep. You aren't children. Daddy government isn't your parent. They are in power because you guys elected them into it. Alright? You guys gave consent to be ruled by a pack of fucking tyrannical heathens. Moving on. In paragraph 15 of the prosecution's memo, counsel refers to cost regulations in reference to a charge being withdrawn or dismissed without trial. However, as a trial had occurred, that'll be the one they lost, the defendant submits this to be irrelevant. In paragraph 30, the prosecution submits that whilst the prosecution sought to withdraw the charge, the defendant submits that this charge, having had a JAT already, refer to Criminal Procedure Act 2011 section 146, where you can only withdraw a charge prior to a trial, this matter can no longer be withdrawn. The prosecution refers to Rule 5.1 of the Road User Rules in paragraph 36 of the memo. The defendant submits that as the defendant is presumed innocent, and as no facts are in evidence to satisfy the onus probandi that the defendant was the alleged driver, or present on that date the alleged offence had occurred, this reference is also irrelevant. See, she wants to say what my arguments are irrelevant. I'm pointing out her comments are also fucking irrelevant, because they live on presumption. The prosecution refers to section 40 of the Land Transport Act in paragraph 37 of the memo. The defendant submits that as the defendant is again presumed innocent, as no facts are in evidence to satisfy the onus probandi that the defendant was the alleged driver or present on the date of the alleged offence had occurred, this reference is also irrelevant. The prosecution refers to section 1331 of the Land Transport Act to a presumption of the defendant being guilty in absence of proof to the contrary. However, the defendant maintains the presumption of innocence in accordance with the Bill of Rights Act 1990 section 25C, and given no facts are in evidence to support the prosecution's allegation, the defendant remains innocent. The prosecution in paragraph 39 of the memo refers to section 145. However, the defendant believes this to be another error and is meant to be section 146. The defendant submits to the court that although a photograph was taken showing FAN 394 on the Northwestern Motorway State Highway 16, that is This is insufficient evidence to satisfy beyond reasonable doubt the burden of proof that the defendant was the alleged driver, as the identity of the driver cannot be established via this photograph, and no first-hand witness has testified to the defendant being the alleged driver. In fact, the witness failed to verify that the defendant had allegedly been the driver of the private motor car associated with registration plate FAN 394. The reason I point that out is because they're talking about a registration plate. That registration plate is only associated with my private property, the private motor car. Okay? Just because I put the plate on it doesn't make it their property. The plate's their property. If I was to sell the car, I'm not, or if I was, sorry, not to sell, but if I was to dispose of the car, I have to take the plates off and hand it back into them, and I might get a bit of a refund for the registration fees that I've paid. But if I destroy the car, I have to hand the plates in because that's their property. The car's still mine. Do you get this point? FAN 394 is not my car. It is a reference like a dog tag or a birth certificate or a firearms serial number. They keep track of the actual possession or property with. Okay? Where were we? We finished that one. Relevant law. Law applicable to costs and jurisdiction. With respect to the prosecution's submissions in relation to the court's jurisdiction to award costs, Section 2 of the Costs in Criminal Cases Act 1967, or the Costs Act, court is interpreted as court, means any court exercising any jurisdiction in criminal cases. Sounds like they've got jurisdiction then, doesn't it? Therefore, the defendant submits that there is no question as to the court's authority or power to award costs in this matter. The many case law references referred to in the memos, pages 16 through 24, appear, although the defendant is not legally trained and lacks the capacity to understand case law, to be referring to self-representing litigants in appellant and high court decisions. These cases are in relations to matters far greater than a Schedule 1 infringement offence and are therefore also irrelevant. In accordance with Section 5, subsection 1 of the Costs Act, this alleged offence was dismissed after a JAT trial had occurred on the 9th of February 2018. The defendant was successful and that the allegations against the defendant were dismissed, not withdrawn, and therefore is interpreted to be a successful defendant. And Kate hated me being classed as a successful defendant. What a pity. It would appear, with respect to the memo 40 on page 40, that counsel is speculating with regards to the possible outcome of a retrial by stating likely to have been successful, and does so without foundation due to lack of evidence and testimony submitted to satisfy the criminal standard of beyond reasonable doubt to the court at the JAT trial on February 9th. The prosecution appears to have taken issue with the use of the word success. The defendant submits that the terminology used in Section 5 as a header, costs of successful defendant, within the Costs Act, noting also the fact that this matter was dismissed, along with the ample evidence submitted within and throughout this response, and during the course of this matter, that a miscarriage of justice had occurred as above in Section 6. Also refer to the Criminal Procedure Act 2011, Section 379. Due to these facts, along with multiple failures of due process as described throughout and above, it is the defendant's opinion that there is clear justification for the use of the term successful defendant. How's that salt getting on for your wound there, Kate? The Cost Act does not refer anywhere to a successful self-represented litigant, as referred to by counsel in paragraph 16 of the memo. The defendant submits that this term is therefore not relevant. In fact, page 173 of Butterworth's New Zealand Law Dictionary, 5th edition, New Zealand Butts Law, defines litigant as litigant, a party to a civil dispute, litigation. The defendant submits to the court that this case is defined as criminal, not civil, the prosecution's use of this term is improper. How'd you like them apples, Kate? The defendant submits that the prosecution had accepted this court to have jurisdiction to hear and make decision in relation to this matter, that the court therefore is in accordance with Section 2 of the Costs Act, has jurisdiction to make determination as to costs. Section 2 of the Costs Act further interprets costs as costs, means any expense properly incurred by a party in carrying out a prosecution, carrying on a defence, or defending an appeal. I was a party carrying on a defence, so therefore my expenses are costs, because they're saying that I'm not a barrister or solicitor, so I don't get costs. I simply get disbursements, meaning my petrol costs and my parking costs, not actual time from me spending in and out of court or researching or studying. The cost claims by the defendant, prescribed within the Costs and Criminal Cases Act Amendment Regulations 2013, or Cost Regulations, Schedule 1, Part 1A1, of $226 per appearance, totalling 4 appearances to $904, are deemed to be appropriate by the defendant. Although the defendant is not a barrister or solicitor, the defendant is a party to these proceedings and has carried out and conducted a sufficient defence in this matter. Counsel have failed to satisfy the criminal standard of beyond reasonable doubt. No facts are in evidence to the contrary. Costs appearances. Firstly, should this court consider any of the below amounts to be unreasonable or excessive, the defendant would accept any such sum the court deems appropriate in this matter with relation to the defendant's 4 separate appearances to date. The appropriate amount of time spent for this matter at court were: first appearance 13th of July, 10 AM to 2:45 PM, 4.75 hours. Second appearance, 7th of November 2017, 9:30 to 3:30, 6 hours. Third appearance, 9th February, 9:30 to 4:30, 7 hours. Fourth appearance, 28th of February, 9:30 to 12 o'clock, 2.5 hours. Furthermore, the defendant notes that the prosecution has to date taken no accountability or responsibility for the many procedural, disclosure, regulatory and due process failures, including, but not exclusively, filing a charging document without any legal provisions on it. Although prosecution sought to point blame at the registry for this error during the 7th November hearing, this error was clearly made by the prosecution, as it is the prosecution's responsibility for the information, or lack of, being on the charging document. In fact, with respect to the counsel's statement, paragraph 30 of the memo, counsel have submitted that the defendant has had the benefit of the infringement being dismissed by consent, given the failure by the Ministry of Justice system in recording the proceedings. Although it was prior to this that Her Honour Judge Mathers had made comments with regards to a miscarriage of justice due to a combination of a defective charging document and that the prosecution failed to provide initial disclosure after multiple requests, the prosecution seeking to withdraw due to the Ministry of Justice failing to keep a permanent court record for the February 9th judge-alone trial, left the defendant at first for a loss for words, as this failure was only the last of many failures. Furthermore, the defendant does not consider defending an allegation, and hundreds of hours spent investigating this allegation, the defendant submits to the court that a dismissal by consent, although consent is not required by a court from a party to dismiss a matter, is not a benefit of any kind, as it would have been cheaper to ignorantly pay the $80 fine and not exercise the defendant's rights. The defendant submits to the court that this matter has consumed a considerable amount of time, effort and resources, resulting in costs and out-of-pocket expenses for the defendant to carry out a defence. The defendant furthermore submits that all other persons involved in the administration, adjudication and prosecution in relation to this matter have been compensated for their time and efforts, as should the defendant due to a miscarriage of justice occurring, as above 6.1. This was prior to the loss of the February 9th permanent court record. Under Costs in Criminal Cases Act 1967 section 5.1, the defendant would accept any such sum the court may deem reasonable. Furthermore, under sections 5.2a, 5.2b, 5.2c, 5.2d and 5.2g, wish to bring to the court's attention the following additional grounds. The defendant submits that the prosecution had not acted in good faith to continue the proceedings due to the multiple failures of regulatory, procedural and due process of law. Refer to Criminal Procedure Act 2011, section 364, where rules of court must be followed. Some failures in this case were: A. The prosecution had failed to supply both initial disclosure by the 13th of July and full disclosure by the 7th of November to the defendant by these applicable dates, also mentioned above, C1 and 2. This is in contradiction to counsel's belief. Refer to page 31 of the memo. Counsel has misunderstood the facts by stating, counsel understands that materially the only matters that the summary of facts included were not already provided were some legislative references relied upon by the prosecution. Well, if you're not supplying them and you rely on them, what does that make your case? The defendant submits to the court that this statement by counsel is also false. As the documents noted above in 119 A, H and I are required to satisfy initial disclosure, which were not supplied to the defendant until the 7th of November 2017 after first being heard, approximately 4 months overdue from the applicable date for initial disclosure. This date was the 13th of July 2017 in relation to the prosecution's case. The charging document appears invalid due to no provisions being noted on the on the document as above 2.1 and 2.2. And the prosecution had failed after multiple requests by the defendant to provide sufficient evidence to support the allegation against the defendant, and the prosecution had failed to fairly and fully inform the defendants of the nature and cause of action of these proceedings. Refer to Bill of Rights Act 1990 section 24a. And it is considered unreasonable and deemed improper to proceed by the defendant given that the counsel in paragraph 7 of the memo state would not meet the public interest test under Crown Prosecution guidelines in all the circumstances. The defendant would note the 10 months taken by the prosecution in this matter are alone justified grounds for dismissal. As justice delayed is justice denied. Refer to Civil and Criminal Justice Statute 1354, section 3. Hours spent on the allegation, costs of petrol and parking. Hours spent by the defendant. The defendant submits to the court that in addition to a total in excess of 150 hours that have been spent by the defendant researching, studying, making inquiries, preparing documents for this matter, that the 150 hours approximately and claimed for is taken from only after the 7th of November appearance. The defendant seeks compensation of $2,250 calculated at $15 per hour, or similar sum the court may deem appropriate for this case. Given that this was the 6th of May 2017 when this allegation first came to the defendant's attention, although the defendant has regrettably not kept any record for time spent on this matter, the defendant estimates an approximate total of over 300 hours have been spent during the last 10 months inquiring, investigating and seeking information. As the defendant values due diligence and thoroughness, and through no fault of the defendant has had to repeatedly ask for documents, which for the first 4 months from the 15th of June to the 6th of October were not responded to by PPS. The prosecution in paragraph 28 of the memo claims the defendant to be double accounting, yet fails to explain how this presumption is drawn by the prosecution. The costs claimed by the defendant for 4 separate appearances are related to a party carrying out and conducting a defence while occupied in court. Refer to Schedule 1 of the Costs in Criminal Cases Regulations 1987, Part 1, Subpart A1. Travel costs and petrol. Out-of-pocket expenses and costs claimed for the travel and claimed under Schedule 1 of the Costs in Criminal Cases Regulations 1987 Part 2 Subpart CA for travelling expenses as party to these proceedings, being that the defendant, not being a barrister or solicitor, is irrelevant. The distance travelled in relation to each appearance according to Google Maps is 35 kilometres each way, totalling 70 kilometres per journey, as the defendant and other family members have had to make many trips to Auckland Hospital since the February 16 due to the defendant's eldest son being diagnosed with ALL, or acute lymphoblastic leukemia. This journey, which is of similar distance, is considered by the defendant, inter alias, or among other people, to cost approximately $20 per journey each instance. As the defendant has also, for well over 3 years, kept a video record published on YouTube under What's That Got to Do with the Price of Gas on the defendant's channel of the price of petrol each week, the price for 95 octane petrol for the appearances dated are, and can be verified via video record, 13th of July, $1.91 per litre, 7th of November, $2.07 a litre, 9th of February, $2.14 a litre, and the 28th of February, $2.14 a litre. An approximate amount of 10 litres is consumed per journey, therefore, on average, to be approximately $20 petrol per instance. Although the defendant cannot produce receipts for each instance, the defendant has approached this cost in all fairness reasonably. 4 times 70 kilometre journey at $20 totalling 80 kilometres. The defendant submits to the court that costs claimed for inquiries, studies, investigations and preparing documents are claimed under Schedule 1 of the Costs in Criminal Cases Regulations 1987, Subpart 2, CBII, as costs of the inquiries and other investigations. Other costs not claimed for by the defendant include, however not exclusively, printer toner, approximately $20, A4 paper, 3 reams at $5 per ream, other miscellaneous stationery, binders, folders, highlighters, dividers. Due to, again, the defendant not keeping receipts for these expenses, the total costs of these items cannot be confirmed and thus not claimed for. Lastly, due to the extent of hours spent researching and making inquiries in relation to this matter after the defendant's second appearance, the defendant has had also sought medication from the defendant's general practitioner due to the lack of rest brought on by studying legislation as to be fully and fairly informed. As a result, the defendant's GP prescribed for a short term a prescription of 10 Zopiclone sleeping tablets to assist the defendant with getting some rest during this time. Refer to references below. This was at a cost of $45 for the GP consultation and $5 for the prescription fee, totaling $50. Parking costs. The defendant seeks reimbursement for parking costs accumulated due to court attendances for this matter incurred at Wilson's Parking, Kitchener Street parking structure, Victoria Street car park. See photo for fees below. The defendant concedes that within the motions for costs on 9th of February, an error had been made by the defendant claiming $100 as opposed to the estimated costs of $96. However, as the February 28th hearing took far less time than had been expected by the defendant, the actual cost for parking on the 28th of February was in fact only $12 and not $24, due to the defendant's motor car being parked just over 3 hours at cheaper rate applied. Actual parking costs, therefore, the actual costs for parking in relation to this matter were, on the 13th of July, $24 for 6 hours, 7th of November, $24 for 7 hours, 9th of February, $24 for 7.5 hours, and the 28th of February, $12 for 3 hours, totaling $84. The defendant wishes to thank the court for its consideration afforded to the above grounds and submissions in seeking costs as a successful defendant for this matter. Total costs sought are: first appearance $226, second appearance $226, third appearance $226, and fourth appearance $226. Inquiries, investigations, study and preparing documents of 150 hours at $15 per hour of $2,250. Travel costs as above at $80 and parking costs as above at $84, totaling $3,318. Conclusion. Throughout this case, the prosecution have A. failed to supply initial or full disclosure and B. failed to respond to multiple requests by the defendant, and C, failed to file a proper charging document, and D, failed to fairly and fully inform the defendant of the nature and cause of the action, and E, failed to create an offence due to improper charging document, and F, failed to satisfy the burden of proof beyond a reasonable doubt, and G, failed to supply any first-hand witness of the defendant being the alleged driver, and H, failed to supply evidence of a temporary 80 km/h speed restriction in effect on the day in question, and I, consumed a large amount of the defendant's irreplaceable time, effort and hundreds of dollars out of pocket through expenses and costs due to this case. The defendant submits that the prosecution challenging the court's jurisdiction after the court already hearing the case and then accepting the court's decision is contemptuous to all involved. Along with the contempt by counsel towards the timetable set by the court in filing the prosecution's memorandum late, shortening the defendant's time to respond, although an apology is submitted by the prosecution, resetting any such contempt, the fact remains that the prosecution did not submit any response by the date set of the 21st of March 2017 by the court. The defendant concludes that the prosecution did not have sufficient evidence under the criminal standard of beyond any reasonable doubt for the court to find the defendant guilty of this alleged offence. The defendant would accept a minimum of $904 for the 4 appearances made by the defendants to conduct a defence and maintain the defendant's innocent in relation to this case, combined with the travel, petrol and parking costs incurred for attending of $164, bringing a minimum total of $1,068. It appears that the prosecution has relied solely through presumptions prescribed within legislation, a photograph and passive acquiescence that the prosecution could possibly gain a guilty verdict against the defendant. The defendant shall accept any such sum the court deems appropriate in this case as to reimburse the losses incurred while as a party conducting a defence in relation to this allegation. The defendant wishes to thank the court for its continued attention to this case and any consideration afforded to granting costs in favour of the defendant at the court's discretion. With respect, me. And this is for submission to the defendant, memorandum of counsel, and remember I said I sent this on the 9th. That massive storm and power cut happened on the night of the 10th, so if I had waited until submitting this on the 11th, which was the due date, I wouldn't have been able to get it through to them. So, yeah. This is the legislative references within this is the Bill of Rights Act 1990, Criminal Procedure Act 2011, the Criminal Disclosure Act 2008, Costs and Criminal Cases Act 1967, Costs and Criminal Cases Regulations 1987, Criminal Procedure Rules 2012, Land Transport Act 1998, Land Transport Offences and Penalties Regulations 1999, Land Transport Road User Rules 2004, Criminal and Civil Justice Statute 1354 and Summary Proceedings Act 1957. Other references within are the ADC from Georgina 3 July and re-recording, in other words stating that I was there to discuss recording with Tim, even though he acted like a complete asshole. Rita, her email, the infringement notice, the cover note, 2 cover notes, photograph, charging document, motion to have the police struck, brief of evidence by Keith Stubley, report from New Zealand Police Infringement Bureau, the email from the amicus, minutes from the judge, the deployment register for the scam, New Zealand Transport Authority details of the particulars for that registration plate, and the scan of the sleeping pills prescription. Dictionary references was must and litigant within a Blacks and Butterworth's Law Dictionary, and the documents attached with the 13th of July transcript and the 7th of November transcript. Obviously I didn't get a transcript for the 9th of February because they tried to block that out. So the other half of that is all of the references I was referring to. So as a special treat for everybody, just to prove that I am absolutely not full of shit, I am going to next on part 33, because I'm thinking that's quite proper considering all the Freemasonry that's going on with these fucktards. In part 33, I'm going to release the actual audio court recording that I have. I'm taken quite some time to balance out the sound and the audio so you can all tell who's saying what and doing what, but you guys can make your own decision as to whether or not this trial was lost because of the witnesses' repeated perjury on the stand and because of them all failing due process. Judge Mathers didn't award me anything. I didn't get any costs. You can see that I have done my homework, that I am talking from a factual point of view. The New Zealand Police and the Prosecution Service solely rely on the presumption written in legislation that the registered owner is deemed the driver of the vehicle. They're not. The photo just shows the fact that the vehicle was on that road. It doesn't say who was driving because they don't care. The amount of fuck-ups they've done, I might want to go and chase them up for some redress, but as we've all heard from Chris Hurd, Senior Solicitor of Ministry of Justice, they're all exempt. Crown Prosecution Services, the Registry, all of those people through their own error and admissions and flat out lies are exempt. And that's where I'm going to leave it. Tune in to section or part 33 when you get round to it, and have a great day. Love you all, hope you enjoyed, and imagine how fucked off they were to have to read 65 pages of that dribble. Payment was all in the reward already. End of. Bye all.